The third petition was E400 of 2020, Third Way Alliance Kenya versus Steering Committee of BBI and others. The substantive issue raised by the petitioner was whether a popular initiative for the amendment of the Constitution of Kenya can be commenced by state actors, in particular the President of the Republic of Kenya. The petitioner further argued that a popular initiative in the amendment of the Constitution cannot be commenced and undertaken without a legal framework for the same. The petitioner sought the following reliefs. A declaration that the Constitution of Kenya Amendment Bill 2020 was not a popular initiative towards the amendment of the Constitution of Kenya. B, a declaration that there is no legal framework to undertake an amendment by way of a popular initiative, to wit, collection of signatures and their verification and conduct of a referendum. And C, a declaration that county assemblies have the power to amend the amendment bill, do not have the power to amend the amendment bill. Number 4, petition E401 of 2020, 254 Hope versus the National Executive of the Republic of Kenya. The petitioner herein urged the court to determine whether the National Executive or any state organ or entities can commence a popular initiative for the amendment of the Constitution of Kenya and utilize funds in the initiation and pursuit of the process. It is sought the invalidation of the entire process, resulting in the publication, approval, and passing of the amendment bill. The fifth petition was number E402 of 2020, Justice Juma and Isaac Ogola versus the Attorney General and others. The petitioners raised the question whether the creation of 70 constituencies by the by the promoters in the amendment bill was unconstitutional, since the function of delimitation of the constituencies is vested in the IEBC. They urged the court to declare as unconstitutional and annul the creation of the 70 constituencies in the amendment bill. The sixth petition was number E416 of 2020, Morara Omoke versus Raila Odinga and others. The petitioner raised the following issues. A, whether the Constitution of Kenya Amendment Bill 2020 can be submitted to county assemblies for consideration, tabled in Parliament for passing or rejection, and transmitted to a referendum in the absence of a legal framework for facilitating the same. B, whether the amendment bill can be transmitted to a referendum before a nationwide voter registration exercise. And C, whether the use of public funds by the President and Honorable Raila Odinga in the initiation and facilitation of the process culminating in the tabling of the amendment bill in Parliament is unconstitutional. And D, whether Parliament has power to act upon the amendment bill following the declaration of its unconstitutionality for want of enactment of the 2/3 gender laws and the advisory opinion by the Chief Justice to the President for its dissolution. The petitioner prayed that the court declares as unconstitutional and invalidates the entire process culminating in the publication of the amendment bill. Petition number 7 was E426 of 2020, Isaac Aluchier versus Uhuru Muigai Kenyatta and others. The substantive question raised by the petitioner was whether the President has power to initiate an amendment to the Constitution of Kenya in the manner relating to the amendment bill and to use public funds in such a process. He contended that the steering committee had converted an illegal presidential constitutional change initiative into a popular initiative. He sought a declaration on unconstitutionality and the invalidation of the entire process. Worthy of notice is that this petitioner sought certain declarations against the President in his personal capacity. And the last petition was number number 2 of 2021, Muslims for Human Rights, Muhuri versus Independent and Electoral Boundaries Commission, and others. The main contention by the petitioner was that the IEBC cannot undertake verification of signatures and registered voters without an enabling legal framework in place, and sought a declaration to that effect. I'll now summarize the responses to these petitions. The Attorney General filed grounds of opposition, raising a total of 12 grounds, which I shall summarize as follows. He stated that a declaration that the provisions founded under Article 255(1) of the Constitution forms the basic structure, entrenchment clauses, and eternity provisions of the Kenya Constitution and cannot be amended under Article 256 of the Constitution or through a popular initiative under Article 257 of the Constitution would be against the express provisions of the Constitution, including Article 255(1), which will have been rendered odious. He added that the petition did not meet the established legal threshold of justiciability for want of ripeness, that the interpretation propounded by the petitioner runs contrary to the constitutionally prescribed purpose mode of interpretation by negating express purposes of Articles 255, 256, and 257 of the Constitution, and that any comparative analysis of foreign jurisprudence could not be used to either contradict or supplement the text of the Constitution of Kenya, that the petitioners were invoking an advisory opinion jurisdiction which the High Court cannot give. The Speaker of the National Assembly, who was the second respondent, raised 9 grounds of opposition. He concurred with the arguments advanced by the Attorney General with regard to justiciability and ripeness. In addition, the Speaker of the National Assembly contended that the petitioners were preempting how the National Assembly would exercise its mandate with respect to the amendment bill, and that the issues advanced could have been tabled before Parliament during public participation exercise as envisaged under the Constitution of Kenya 2010 and the standing orders of the House. The second respondent further argued that the High Court lacked jurisdiction to intervene in active parliamentary processes, and therefore any challenges to the amendment bill had to await the completion of the legislative process before the jurisdiction of the courts can be invoked to challenge the bill. The Speaker of the Senate, who was the third respondent, also filed grounds of opposition, raising 8 grounds. He reiterated the grounds argued by the Attorney General and the Speaker of the National Assembly. He stated that the people of Kenya have the sovereign right to amend the Constitution in the manner prescribed under Articles 256 and 257 of the Constitution. On their part, the BBI Secretariat and Honorable Raila Odinga filed consolidated grounds of opposition, raising 10 grounds, most of which were a replica of the grounds raised by the first, second, and third respondents. They also filed an affidavit that was sworn by Mr. Dennis Waweru, who stated that he was one of the co-chairpersons of the BBI Secretariat and its co-chairman was Honorable Junet Mohammed, that the Building Bridges Initiative was created and mandated with the task of initiating a constitutional amendment process and unifying Kenya among other functions. Mr. Waweru deposed that Article 1 of the Constitution of Kenya 2010 vests sovereign power to the people of Kenya, and such power is to be exercised only in accordance with the Constitution of Kenya 2010, that the Constitution is not a rigid document, and pursuant to Articles 255, 256, and 257, it can be amended as provided for in the said provisions, that if the framers of the Constitution did not intend that the Constitution be amended, nothing would have barred them from having such an express provision included therein. Regarding the doctrines and theories of basic structure, constitutional entrenchment clauses, and unamendable constitutional provisions as proposed by the petitioners, Mr. Waweru stated that they were mere theories and hypotheses only applicable in different jurisdictions and relevant depending on the special circumstances of each jurisdiction. The IEBC contended that in the exercise of its powers under Article 257, it enjoys constitutional and administrative, decisional, and financial independence, that it carried out its constitutional mandate of verifying that the constitutional amendment initiative was supported by at least 1 million registered voters, that it was erroneous for the petitioners to argue that there was no legal framework for verification of registered voters, as the provisions of Article 257 made it possible for the actors to know their obligations, and therefore there was no basis of making any finding against it. For making any finding against it. In respect of the petition by Mr. Isaac Aluchir challenging capacity of the President to initiate a popular initiative for amendment of the Constitution, the President did not respond to the petition at all. However, the Attorney General filed grounds of objection, stating in the earlier that the President, Uhuru Muigai Kenyatta, cannot be sued in his personal capacity for any acts done during the pendency of his presidency, that the issue of constitutionality of the President's functions is res judicata, and that monies expended on the President's constitutional functions could only be audited by the Auditor General. The court could not be involved in such an issue. Having perused lengthy affidavits, written submissions, copious authorities, as well as oral submissions by counsel, the High Court made the following declarations. A, that the basic structure doctrine is applicable in Kenya. B, that the basic structure doctrine limits the amendment power set out in Articles 255 to 257 of the Constitution. In particular, the basic structure doctrine limits the power to amend the basic structure of the Constitution and eternity clauses. C, that the basic structure of the Constitution and eternity clauses can only be amended through the primary constituent power, which must include 4 sequential processes, namely civic education, public participation and collection of views, constituent assembly debate, and ultimately a referendum. 2, a declaration is hereby made that civil court proceedings can be instituted against the President or a person performing the functions of the office of President during the tenure of office in respect of anything done or not done contrary to the Constitution. 3, a declaration is hereby made that the President does not have authority under the Constitution to initiate changes to the Constitution, and that a constitutional amendment can only be initiated by Parliament through a parliamentary initiative under Article 256 or through a popular initiative under Article 257 of the Constitution. 4, a declaration is hereby made that the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report established by the President via Kenya Gazette Notice number 264 of 3rd January 2020 and published in a special issue of the Kenya Gazette on 10th of January 2020 is an unconstitutional and unlawful entity. Number 5, a declaration is hereby made that being an unconstitutional and unlawful entity, the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report has no legal capacity to initiate any action towards promoting constitutional changes under Article 257 of the Constitution. Number 5, number 6, a declaration is hereby made that the entire BBI process culminating with the launch of the Constitution of Kenya Amendment Bill 2020 was done unconstitutionally and in usurpation of the people's exercise of sovereign power. Number 7, A declaration is hereby made that Mr. Uhuru Muigai Kenyatta has contravened Chapter 6 of the Constitution and specifically Article 73(1)(a)(1) by initiating and promoting a constitutional change process contrary to the provisions of the Constitution on amendment of the Constitution. Number 8, a declaration is hereby made that the entire unconstitutional constitutional change process promoted by the steering committee on the implementation of the building bridges B, and is hereby made that the second schedule to the Constitution of Kenya Amendment Bill 2020, insofar as it proposed to have determined by delimitation the number of constituencies and apportionment within the counties, is unconstitutional for want of public participation. Number 17, a declaration is hereby made that administrative procedures for the verification of signatures in support of constitutional amendment referendum made by the Independent Electoral and Boundaries Commission are illegal, null and void because they were made without quorum, in the absence of legal authority, and in violation of Article 94 of the Constitution and Sections 5, 6, and 11 of the statutory. The IEBC, in its memorandum of appeal, raised 12 grounds of appeal, which I will summarize as hereunder. That the
Kameme TV, Muthegi wa Ruriri.
The meter